Mr. Sims.
Good morning, my lord and my ladies. I appear on behalf of the appellant in this matter with Mr. Jagazia, as in the court below, and Mr. Ayres, Leeds Counsel, appears on behalf of the respondent, as he did in the court below, with Mr. Sher. So far as housekeeping matters are concerned, hopefully you will all have received safely the core bundle and a supplemental bundle and authorities bundle, which has been updated this morning with a couple of additional authorities which were submitted to court yesterday. We've also received, thank you, a brief note which was just handed to us, I think, shortly before we started.
And I wouldn't expect you to have read the case and taken it on board yet, but it would be helpful if, in the course of your submissions between you can take account of it.
Yes. On my brief look at it, I anticipate it mainly arises on my learned friend's cross-appeal, though if I've misread the significance of it and I need to consider it, I'll look at it over lunch in German and bear it in mind. So far as the question of the housekeeping in terms of timing, I've had a brief discussion with my learned friend as regards to this, and subject to anything that you may have to say about this, in broad terms, what we propose is that I open our appeal this morning, and then my learned friend responds to that and opens his cross-appeal this afternoon, and then in relation to a response, I anticipate I may need about an hour, perhaps less, tomorrow in terms of response, and then if we need it, replies on those responses. But I suspect by the time we get to the close of today, we'll have a better idea as to timing tomorrow. But suffice it to say, our internal plan, subject to anything you may have to say, should ensure that we're completed within good time in the 1.5 days.
No, well, that all sounds very sensible. It had occurred to us that things might, in the event, move faster than the 1.5 day estimate suggested. And if they prove to, then of course that will be welcome.
Yes, well, certainly if you feel that we're labouring points which we don't need to, then we will take judicial or bar notice of that and try and do our best to deal with things as efficiently as possible. There are some points which I think it would be helpful just to set the context of the submissions to take us through in relation to the judgment, which is quite a lengthy judgment, and also there's some law to go through. Ultimately, you, as is always the case with these things, when you pinpoint exactly what the issues are, that tends to speed things up.
Yes. I mean, I should say, as I think you would have anticipated anyway, we have all obviously done our pre-reading, so we know what the case is about. So unless there's anything else in terms of preliminary matters that I should draw your attention to or respond to questions of, I'll simply proceed to open our appeal. Yep.
I'm grateful. So as you'll appreciate from the grounds of appeal in the skeleton argument, the focus of the appeal concerns the judge's assessment of damages and quantum in a breach of warranty claim based on a share purchase agreement dated the 14th of October 2015 in relation to the sale of shares of the waste disposal company based in Newport, Gwent, called GDE, and that's a sale by the defendants, the Norvilles, to the respondents, the claimant, MDW. The material findings of the judge, so far as findings of liability are concerned, are set out concisely by the judge in section J of his judgment, and you may want to just briefly have the judgment open in front of you for the purposes of this brief introduction to the case. It's in core bundle behind tab 5. And it starts at page 46. There's a helpful content section, paragraph 5, and I'm going to use the letter references contained within that content section to guide you to the parts of the judgment which we'll be looking at in due course. But for present purposes, I was going to just briefly invite you to go to the summary section on liability at J before then moving on to K, which is of course where the argument is focused. So far as the summary section is concerned, that's page 154, and it starts at paragraph 277 to 279. And you'll appreciate from reading the judgment that there are a number of matters in issue in the court below, all concerned with allegations of non-compliance with various environmental regulations. And the nub of the claim in the court below, so far as quantum was concerned, was the additional cost of compliance in relation to the areas of non-compliance which have been established so far as the claim was concerned. And that was pursued across broadly 3 different areas. One was to do with discharge of leachate, which is effectively the runoff from landfill sites, which is collected in and then is processed by GDE on site and then discharged into the sewer. And the allegation which was made out was that in relation to that, there were persistent excesses on the discharge consent limit so far as the, in particular ammonia, but also certain metals were concerned in relation to the discharge limits. The second element of the claim was an allegation about what was referred to somewhat colourfully as the magic hole allegation in relation to cess waste being dumped down a magic hole. And whilst that was a colourful diversion at trial, ultimately it landed on nothing so far as damages were concerned. And the third element was then to do with allegations in relation to disposal of tank bottom waste. And in broad terms, what this related to was an allegation that a layer of sludge was inappropriately taken out of certain tanks and mixed with dry waste in order to hide it, again to minimise the cost of disposal. That allegation was ultimately substantially rejected by the judge. So we were left with one main finding on the allegations pursued below. But the interrelation between those 3 different streams and the consequences those had in terms of the quantum claim was a vexing matter throughout the litigation in the court below. Ultimately made it very difficult for everyone to know exactly where the loss lay in terms of the position at trial. So where we get to ultimately for the purposes of this appeal is really summarised at the end of paragraph 278 for the purposes of our appeal, which is that the relevant breaches concern the discharge of leachate. And that was twofold, both the fact that there'd been breaches of the 2012 consent in relation to the levels, but also the threat of prosecution and the likelihood that the breaches would result or potentially result in a revocation, suspension, discharge or alteration of the 2012 consent. And you can see that earlier finding so far as the precise finding the judge made in that respect. If you want the reference for it, it's at paragraph 218 of the judgment, which is the sort of key link paragraph back to that particular finding, where you'll see the judge makes the finding of a breach of a warranty, paragraph 29.2, and makes the finding that the regulators were misled and there was a persistent failure to bring discharges of effluent within the scope of the 2012 consent. So that was really the key finding which was then carried through into the quantum assessment thereafter. And you can see that so far as the allegations were concerned in that respect, there were 2 regulators potentially of relevance in this respect. The main one for the purposes of the leachate was Welsh Water, who were the relevant undertaker for the purposes of the discharge into the sewer. But there was also what was known as the Environment Agency, now Natural Resources Wales, who were also a regulator who potentially might have brought relevant action against the company and its officers as far as breaches were concerned. And obviously that created a potential risk to GDE insofar as its future business was concerned, though as we know, because it was explored in detail at trial, as the events turned out, there was no revocation, suspension, variation or discharge of the permits, nor was there any prosecution by the regulators, nor indeed were any proceedings taken to to prosecute. GD carried on processing the leachate and wet waste at the same turnover as before the SPA with the same customer. So there was no loss of goodwill and no risks eventuated in relation to the matters which prospectively would clearly have been viewed as potentially of some concern to a buyer. I'll come back to the question of the interrelation between the adjustments the judge made on both sides of the equation in that respect, just to explain our case in a bit more detail. But that's the broad framework, the backdrop, if you like. And so far as the losses were concerned, and proving the losses, the expert evidence of Mr. Gates was used for two reasons. One was to actually show breaches, but also on losses. And the basic methodology which he used, but which was then modified by our expert, for reasons which I'll come on to shortly, was to look at the losses on the basis of taking the increased cost of disposal in order to run a compliant business in the 2 years after the SPA, looking at the conduct of GDE under the management of the new management, and assessing losses on the basis that this increased cost was the cost of running a compliant business, which should have been factored in when assessing the true or actual value of the business at the date of the SPA. So you can immediately see right at the outset this is a very unusual case, because we're starting out at a premise that the events after the event, which we argued against in the court below, on the basis we said, well, this is all very unsafe, because how do we know that the performance of the business after, the 2 years after, just wasn't incompetent, or that there are increased costs associated with all these things which would have caused an increase in the figures rather than a decrease in the figures. But ultimately, notwithstanding the fact it wasn't our primary contention that the losses should be assessed on this basis, the judge gave that benefit to the claimant for the purposes of assessing their loss and the reduction in the multiplicand figure, the earnings figure. Now, so far as the appeal is concerned, there's of course no findings, no appeal against the findings of liability, and we don't shrink from any of those findings for the purposes of this appeal or seek to diminish them in any way. Nor, for the purposes of our appeal, do we shrink from the findings that, in certain respects, for the purposes of the contractual allegations, it's equivalent to finding of a deliberate breach, an intentional breach. But this appeal, in this case, is not concerned with punishing the defendants. This appeal is concerned with ascertaining true and fair compensation in accordance with the overriding compensatory principle. So the focus of the appeal obviously concerns the judge's assessment of quantum for breaches of warranty, and in particular his assessment of what is referred to in the evidence as the warranty false side of the equation. This is a little confusingly also sometimes referred to as the actual true value. And indeed, I think in my learned friend's pleading case, that's the way round it's pleaded. So you need to be a little bit careful not to confuse yourself between those two concepts. But I don't think we did or the judge did in the court below, but I just mention it because it can sometimes cause some mental gymnastics when looking at the matter. There was a common basis for how the matters should be assessed so far as quantum is concerned in the court below. And having invited you to look at section J, I'm now moving on to section K of the judgment, and in particular paragraph 280. And you will see there that the judge correctly recorded that it was common ground that the proper measure of damages for breach of warranty was the difference between A, the value of GDE on the basis the warranties were true, or what's termed warranty true, and the actual value of GDE given that the warranties were false. And that is because that's the common method used in order to give effect to the overriding compensatory principle where there's a breach of contract. Because in the breach of contract case, of course, we're looking at putting the party who's been wronged so far as a breach of contract is concerned in a position if the contract had been performed. And so on this hypothesis, if the contract had been performed, the warranties would have been true, and they would have got a business on the basis of those warranties being true, as against the breach position, which is the warranties were in fact false. You'll note that the judge then goes on to say no different measure has been suggested for any claim in respect to fraudulent or negligent misrepresentation, at least for the purposes of this case. And then he goes on to refer to and makes findings on breaches of warranty so far as quantum is concerned. Of course, the latter part of that paragraph is a focus of submissions and argument on the cross appeal. But if we move on, we can then see the analysis of the judge on quantum, and he sets out some general principles as regards how he should approach that, which I don't think there's any substantial controversy so far as that is concerned in paragraph 281. And then we have at paragraph 282, he then traces his way through the claim as pleaded and in the expert evidence. You can see in paragraph 283, he notes a pause for thought as regards the jackpot damages that were being sought by the claimant and the lack of reality those bore with the underlying allegations as found by him, so far as the impact on these breaches on the underlying business was concerned. And in particular, you'll note that the findings that he's made concern one aspect only of the wet waste division and a small percentage of that wet waste division as it was. And he noted that the wet waste division accounted for 25% of the gross profits. So ultimately, he reminds himself quite properly here that an elimination of the whole of the wet waste division would be measured in broad terms in the figures that he's identified there. That's obviously a check to some of the more outlandish claims brought in the court below, but as we'll come on to in a moment, we respectfully submit needed to be cross-checked again so far as the ultimate figures that the judge ended up with. So far as paragraph 284 and 285 are concerned, you can see that the judge makes his findings as to the value of GDE on a warranty true basis at paragraph 285. There's no appeal against that part of his judgment on the findings, but you can see the methodology he uses there and the reasoning he gets to it, which is in effect to use an enterprise value or EBITDA earnings multiplier approach involving an equation which then leads you to an enterprise value which is net of the debt which the company had at the time. And ultimately, he prefers Mr. Mesher's analysis so far as the position was concerned, and you can see at the end of paragraph 4 he notes that both experts viewed an EBITDA multiplier to justify the purchase price as being on the high side, and he ultimately concluded that the multiplier suggested by Mr. Mesher, independent of the purchase price, was the correct one, and so he therefore made his findings as to warranty true on the basis that the warranty true price was less than the purchase price. You can then see in paragraph 286 he sets out his approach to warranty false valuation, and the first step of that is to consider the earnings and the reduction on earnings required as a result of the breaches found. And you can see that in effect he adopts the reasoning of Mr. Mesher, which we can find earlier on in the judgment in the section in section D, in particular paragraph 139 onwards, which we can come back to in due course if we need to. And so 287 is the first step to the process. Then, very unusually, and so far as we're aware, without any precedent, so far as the actual case we've been able to find in the reports, he went on and made a reduction in the multiplier to reflect reputational damage, or as it been put in argument, the fragility of the goodwill that the breaches were liable to cause the company and the jeopardy that they occasioned to the future of the business. So it's in particular that part of the judgment from paragraphs 288 onwards which we seek to examine more closely on this appeal, and in respect to which we submit the judge erred in terms of his approach and his analysis and his conclusions. But just sticking with the essential nub of the reason why the judge concluded concluded that was appropriate. It was for breaches which are liable to cause the company and the jeopardy that they occasion to the future of the business. So it's looking at risks which had not then eventuated, but which would eventuate in the future, or potentially eventuate in the future. And he then refers to the expert evidence, which was, in effect, as you might conceivably have an argument about the multiplier. But as he noted earlier on in his judgment, there was a disagreement as to whether or not it was appropriate. Mr. Mesher concluded that it wasn't appropriate for there to be adjustment to the multiplier. Mr. Gates suggested a very outlandish 25%. He rejected that, and you can see he deals with that in paragraph 289. But before I get to 289, you see at the end of 288, he rejects the argument which we made to him in the court below, that no discount would be appropriate because it's known that no risk to the business would be realised since the SPA is to be rejected, as it relies impermissibly on hindsight. So he rejected our submission that he could take into account events after the event for the purposes of assessing the reduction in the multiplier, yet he had taken into account subsequent events through the expert evidence of Mr. Mesher and Mr. Gates for the purposes of assessing the reduction in the multiplicand. He then goes on and discusses why he rejects Mr. Gates' suggestion of a 25% discount, and he makes various findings as to why that's completely inappropriate, and he then refers to the evidence of Mr. Mesher in paragraph 290 on there being a potential range, with Mr. Mesher saying a range between 3.8 and 4.5, and he then concludes at the end of that paragraph, having regard to the matters I've referred to above, I consider the risk of reputational damage is appropriately reflected by discounting the multiplier from 4.2 to 4. And he then translates that into the conclusion as to what the damages should be in paragraph 219, and you see it in effect brings the figure up from just under 160,000 to a figure of in excess of 380,000. So a doubling of the award as a result of that adjustment. He then considers and rejects an argument based on expert evidence from Mr. Mesher, which was to the effect that there should be a cap on the assessment of the damages here because of evidence that the breaches, or at least in any event the main breaches identified, were resolvable through remedying those through adjustments to the plant. So basically the problem in relation to the plant and the position before and after the SPA was that the Hydro Venturi plant was not fully automated, was being run on a semi-automated basis, and the findings in effect were that there were insufficient staff to deal with the throughput, and the position was that there was too much waste being taken in to be able to, for that particular machinery and the setup, to cope with it. And the solution adopted afterwards by the new owners of MDE was to contract out waste which couldn't be processed through in terms of volume to a third-party contractor called Tradibi, and that additional cost was then factored into the equation so far as the reduction in earnings were concerned. And of course that conduct on their part did cure the problem in the sense of it resolved the risk of allegations of non-compliance, and of course there was no subsequent prosecution or difficulties which caused loss of business. But ultimately the judge rejected the cost of cure argument, and you can see the reasoning why he did so in paragraphs 293 onwards in the judgment. And I'll come back to deal with those points each in turn as to why we would submit that even if they don't operate or weren't to operate as a measure in their own right, they were a factor in the reason why the damages figure which we ended up with was overblown. In those circumstances, he obviously makes his findings at the end in paragraph 294 as the award. So with that brief scene setting in mind, I propose now to move to our grounds of appeal. And ground one is, of course, focused on the question of the judge's rejection of the submission at the end of paragraph 288 of his judgment. And there are two overarching submissions we make on this ground. The first is that the judge should have accepted the submission we made, that regard should be had to what's happened after the data breach when assessing at the data breach the reputational damage, in inverted commas, of the breaches were liable to cause the company and the jeopardy they occasioned to the future of the business. So that's limb number one. And then in fact, limb number two is, even if in a conventional case, a judge might otherwise be justified in rejecting that approach, because of the way that quantum case, indeed breach case and quantum case was advanced in the court below, and assessed in this case, the rejection of that approach in this case is inconsistent with the overriding compensatory principle, manifestly unjust and wrong. And in particular on that latter point, it should be noted at the outset that the very post facto material and evidence which was examined and then used to justify the reduction in the multiplicand, the earnings figure, showed the risk to the business did not eventuate. But this was ignored when it came to considering whether there ought to be a reduction to the multiplier. We can find no authority in support of the idea that you can chop and change like that as between different elements of an assessment process. At its highest, it may be said that the court ought not to have taken into account hindsight at all. If it had done that, then the claimant's claim would have failed. They're on their own evidence and the way they prosecuted the case, quantum would have been assessed at nil. So properly understood, what we are in the scenario here is the claimant had already received the benefit of a post facto examination, and it's in that respect, so far as we're aware, unprecedented insofar as the context that then provides for consideration of the principles before this court. And that means that I'm going to spend a little bit of time just going through the cases now to look at what those principles are, because the nub of our submission is that ultimately there's only one firm rule or principle, which is the overriding compensatory principle. And
so, sorry to interrupt you, Mr.
Yeah.
Sim. So it means that actually you're saying they've used post-dated information for one part, but not for the other part of the equation, so to speak.
Yeah.
But in relation to that first part, which is determining the value of the business, how would one go about doing that without taking account of actually how much it cost to do this properly?
Well,
I'm a little bit confused about how else one would work it out.
You certainly would, and that's the key part of the equation. But the point is not the ultimate mathematics or the equation used, but the use of evidence in order to carry out that assessment exercise. So in a conventional case, what you would do is you would look at the underlying materials insofar as the materials processed through the plant in the period in advance of the date of the contract. You would assess those. You would look at what was the plant capable of processing, having regard to the employees who were manning or running the plant in question, and you would come up with a figure on that basis, and that may be capable of being dealt with solely on the basis of the factual information. It may require some expert evidence depending on the amount of the factual information. But that's the way you'd prove your case without having recourse to events after the event. And another way of doing it, which is what our expert came up with, is cost of cure. So you and it's a different type. They're both types of cost of cure.
Cost of cure is post-event as well, of course.
Well,
it may not be.
No, I don't think it is in the same way, because what you're doing is you're hypothesising that you know about the breach prospectively, and you're asking yourself, what would a hypothetical...
What would a purchaser
exactly
think that they're going to put in?
And they would ask themselves, well, why is this plant not capable of processing? We can see that there's 80 cubic metres daily is what the consent says, and these are the limits. What's the problems? And the manufacturer would say, well, we recommended automated right at the outset. These people skimped on it, didn't go for a fully automated system. So roughly speaking, what would that cost us? And you have a figure. And in fact, we did have a figure in the court below on that. But the judge, for reasons which we'll come on to, rejected that. So the short point is we absolutely don't accept the proposition that this was a case of not being able to prove your case by reference to
Just wanted to bottom that out. Thank you.
Yeah. But you're absolutely right that conceptually you can put these different types of hindsight uses into all sorts of different conceptual subcategories. But are they a principal distinction is I suppose the question for this court. And in our respectful submission, they're not. If you start to use hindsight as part of the process in order to come up with what you, the first instance judge, consider to be a fair figure reflecting the actual losses suffered by the entity concerned, it's manifestly unfair to then shut your eyes once you've started that process. And we don't submit in this court that it's impossible to do that. We strongly argued in the court below that it wasn't the preferred approach. But if you do that, then it's in our respectful submission, just fundamentally unfair and inconsistent to chop and change. And it's not an answer to simply say, well, the after the event evidence that we were taking here related to ascertaining the position prior to the date of the SPA, whereas actually what you're seeking to do is you're seeking to take into account after the events to assess a contingency at the date of the SPA, but in relation to what happened after the SPA. We would simply say in response to that, well, the reason why the courts are disinclined to allow hindsight in is because there's a risk that in doing that, the court won't arrive at the overriding compensatory principle figure, because you then introduce, well, how was the plant operated after that time? Was that due to operator error or other intervening factors?
How efficient was it?
Or all sorts of other factors. And so that's why the court is usually, in most cases, disinclined to move from the data breach, both on data breach and also taking into account events after the event. But as we'll see from the cases we'll look at, that's not an immutable rule. And if it was an immutable rule which is applied to this case, then you already have my submissions on that, which is we've ended up with a zero figure. So I re-emphasise this was very much for the benefit of the claimant so far as what happened in the court below. And we very much object to the attempt to portray this as us in some way, seeking to take some unscrupulous advantage of a slip up or that we got away with it in some way. That's manifestly unfair to us in certain circumstances where the claimants themselves have had the benefit of that 2-year inquiry period in order to inform and ultimately prove their case on quantum. So the principles, I can trot through them as quickly or as slowly as is appropriate. I suspect quickly to begin with is probably what's preferred, and then at points we may slow down or interrupt. But as I said, the starting point is that there is only one firm rule or principle when it comes to assessing damages in contract or tort, and that's referred to as the fundamental or overriding compensatory principle. And what follows in the assessment exercise is to give effect to that. You probably don't need any citation of authority for that, but see Lord Reed in one step at paragraph 25, referring to tort, and paragraphs 31 to 35 referring to contract. And of course, he refers in those passages back to the seminal cases of Livingston, Royal Yards, so far as tort is concerned, and Robinson and Harman, so far as contract is concerned. And as made clear in those authorities, whilst the court may adopt normal measures for certain types of cases, and in contracts of sale cases that the measure will normally be measured at the date of breach without reference to subsequent events, the question will remain whether in all the circumstances of any particular case, the normal measure properly reflects the overriding compensatory rule or principle. And there's a pithy judgment to that effect at first instance by Mr. Geoffrey Voss of Queen's Counsel, as he then was sitting as a deputy, in a case called Pancania, which is cited in a case called Bacciottini at paragraph 48, and that's also in the authorities bundle behind tab 13 at page E269.
Sorry, the paragraph number was...
If I'm rushing this point, perhaps we just briefly look at it.
Okay.
So the Bacciottini case is a recent decision of the Court of Appeal behind tab 13, so page 261 of the bundle. And you can see that the judgment which we're looking at is the judgment of Lord Justice Davis. If you want to look at the internal pagination on the report, that's at page 98 or page 262 of the continuous pagination. But the passage I was just going to invite you to look at, so far as principles were concerned, in relation to the Pancania decision, that's at paragraph 48. And that's at page 98 of the internal report, or 269, the continuous pagination. And you can then see approval of that by the Court of Appeal if approval is required. It's paragraph 57. And you can see just about in the middle of that paragraph, the Court of Appeal recognises the neat and accurate summary in the Pancania case in that respect. So really all roads in this case lead back to that one rule principle. And the cases which I'm now going to go on to, whilst they're earlier in time, are really a reflection in certain respects of the court seeking to ensure that they award the person who's suffered the breach of contract their actual losses. And the particular issue, which of course, arises in this context so far as hindsight is concerned, it is the case, or the principle sometimes referred to as the Wilfer principle, which is obviously named after the decision in the Wilfer and Merthyr Dare Steam Collieries case in 1903. And the essential point is whether subsequent events may be regarded or taken into account when assessing the true value or loss at the date of breach. So it's not a case where the date of breach date is moved, but the court takes into account subsequent events. And there are some general statements of principle to be found in Wilfer supporting the notion that you can use hindsight to assess value at the date of breach. There's been debate since then as to whether or not the principle should be confined to certain types of cases or qualified or caveated. And as we'll see when we come to consider the later authorities, the notion that it should be confined to certain types of cases has been rejected in subsequent decisions of the House of Lords and the Supreme Court. The general principle which we submit emerges from it is that when the court comes to make an assessment, when it knows something, or it has better information and evidence about something which was uncertain or unknown or contingent, at the time of the breach. The court can, in inappropriate cases, should have regard to the latter and better information if it enables the court to assess more accurately the true or actual loss in order to give effect to the compensatory principle. Now, the case itself is behind tab 3, and you're probably all very familiar with the case and the principles, but just briefly to touch on the passages which are then later picked up on in later cases. If you look behind tab 3, you'll see that the case itself wasn't a contract or tort case at all. It was a case concerning compensation, statutory compensation. But the point which arose in the case, as you'll see from the head note, related to the fact that a counter notice had been served requiring the miners not to work, and as a result they ceased work in certain material respects. And then there was an issue arising as to, in relation to the valuation of their losses, whether or not that should be restricted by reference to information at the date of the counter notice, or whether or not subsequent evidence and information about prices and value could be taken into account when assessing the actual loss. And ultimately the House of Lords concluded the latter. The passages are marked up already in the bundle in front of you, but in order of the speeches. Firstly, the Earl of Salisbury, Lord Chancellor at the time, you can see at page 429 of the internal report, you have the quotation which is then picked up in lots of subsequent cases as to not shutting your eyes to the true sum, now you know it, etc. And also then Lord Norton in a later passage, which again is also marked up, why listen to conjecture on a matter which has become an accomplished fact, etc.
That's 431, isn't it?
That's at 4.2. That's at 4. Actually, it's 431, I think, of the
Yep.
continuous pagination. And then the third speech, which is commonly referred to as well, is Lord Robertson, to similar effect near the bottom of page 432. And if, owing to the course of the procedure, the period required for working out of the column question has come to the matter of history, then estimate and conjecture are superseded by facts as the proper media concludendi. Putting it in plain English, if as a result of the fact that you come to assess something later on down the line and you know actually what a true figure is or a true loss is, then you can, in appropriate cases, and they, including the facts of this case, should take into account those facts when assessing loss. Now, this case obviously didn't concern a contractual tort case, but it was being picked up on in later cases, and this general principle has been found to be good and established so far as when the court is seeking to award compensatory damages, which of course is the vast majority of cases before the court. A more recent affirmation of those principles, in fact, I'm accelerating on 100 years, you'll be pleased to hear, rather than taking you through every single case in the intervening period, but in a different context, again, from the context we're looking at, but just to sort of show you that this is a wide-ranging principle which is not sort of confined to any particular category. It is the case of Phillips and Bruin Dolphin, which I apprehend some of you will be familiar with as well. And there are some observations in Phillips and Bruin Dolphin. It's behind tab 7 of the authorities bundle, which foreshadow the speeches in the Golden Victory to come a little later. But you'll see that the issue in Phillips and Bruin Dolphin was to do with assessing the value of a subsidiary company in the context of a transaction that's an undervalue allegation for the purposes of Section 238 of the Insolvency Act. And so the question arose, and if you look at the second holding in the head note, was for the purposes of assessing that value, how the court should approach what was a precarious covenant as part of the contractual transaction in order to assess what the true value was in circumstances where the court knew what had happened in relation to that covenant by the time it came to assessment. And as you can see from the holding, the House of Lords concluded it should take that into account for the purposes of assessing value on the singular event, i.e. the transaction at undervalue event. And it's again the speech of Lord Scott here, which is where the relevant principle is contained, and that is marked up for you, we hope, at page 153 of the internal report. And you may just want to briefly read there. You can see echoes or in effect, similar observations to that of the House of Lords some 100 years previously.
So you'd like us to read paragraphs 26, 27?
Yes, please.
Yeah.
Now you'll see there's, again, a recognition that the court can take into account hindsight. In this case, a slightly different type of use of it than the earlier Wilford case. Obviously, the earlier Wilford case was to do with extraction of coal over a period of time. And here there was a one-event transaction, but nevertheless the court considered appropriate to take into account again in this context. And a sensible warning that the answers may not be uniform, that may depend on the particular context in which the problem arises. We don't all automatically assume that in every single case the court has to do this. Of course, it needs to be considered in the context of the neat summary of Mr. Geoffrey Voss, as he then was in the Pancania case. As we see, of course, in a decision and a speech of Lord Scott a few years later, he applies, in fact, the same principle in the Golden Victory, along with the majority in the House of Lords. And that's the next case I was going to turn to behind tab 8. And you'll see the context of this case was a charter party repudiation case. And you'll see in the holding the majority concluding that the principle that damages should be assessed at the date of breach was not inflexible, and the desire of achieving certainty in commercial contracts was subject to the overriding compensatory principle. The damages awarded should represent no more than the value of the benefits which the claimant had been deprived. And then goes on to say that if at the date of breach there had been a real possibility that an event would happen, terminating the contract or otherwise reducing those contractual benefits, the quantum of damages might need to be reduced proportionately to reflect the estimated likelihood of that possibility materialising. But where such an event had already happened by the time damages were assessed, the court should have regard to what had actually occurred, so that estimation was no longer necessary. And that again is the core principle which is being applied across all these different cases. If we look at the speeches, starting with Lord Scott, In particular, we've marked up the passages for you, but at page 379 of the internal report,
so you've marked paragraphs 29 through to 32.
yes.
Is it going to make sense for you to take us to particular passages or for us to read those paragraphs?
I think it would probably be easiest for you to read them. We've already picked up on most of the material quotes in our written argument in any event in the skeleton, but just to set the context for the submissions,
Shall we just read those paragraphs then?
you could, and I might add, as far as Lord Scott's speech is concerned, if any of you are quick readers, there's paragraph 36 to consider as well later on.
Yeah,
but
well, let's do that.
I'll leave you to take your time on that. So in short then, looking at those passages, as you'd have already seen from paragraph 36 of our skeleton, we pick up on the quoting in paragraph 30 of the speech. In particular, the passage next to D, the claimant is entitled to the benefit expressed in money of the contractual rights he has lost, but not to the benefit of more valuable contractual rights than those he has lost. And we also draw attention to the emphasis on the flexibility and the assertion that data breach can't be departed from is inconsistent both with principle and with authorities, and the underlying principle being obviously the compensatory one, which is then followed through into the later passages within paragraph 32, with the court getting nearest it can to an accurate assessment. And in paragraph, at the end of paragraph 35 and into paragraph 36, you see a reaffirmation of that, and an emphasis that any rule which requires damages to be treated as in some way attributable to a false basis, as may be called, would be inconsistent with the overriding compensatory principle. And you then see the quote in paragraph 36G, which is then subsequently picked up on in other cases as the lodestar is that the damages should represent the value of the contractual benefits which the claimant had been deprived by the breach of contract, no less but also no more. And that is what the court is in all cases is seeking to do, and the Wilford principle is a reflection of that particular principle in the context of cases where the court is coming to assessment knowing events after the date of breach, by which it can more accurately assess the actual loss suffered by the person who suffered the breach. We had also marked, a brief passage at the end of the judgment at paragraph 38, and the rejection of the notion of commercial certainty being something which required something different. So I just briefly draw your attention to that. That point is also picked up on in the other speeches of the majority. So if, for example, you look at Lord Carswell, Lord Carswell's judgment at page 391, the same point is emphasised in paragraph 63, which you may want to just briefly read.
Yeah. Shall we just do that? Yes.
And finally, to complete the trio, Lord Brown, the material passages are at paragraph 78, again marked up.
Let's read that one.
Yes, and also 83. Now, there was some academic debate following those cases as to whether or not actually the principles propounded in the Golden Victory and earlier cases might be restricted to cases involving continuous contracts or services provided over a period of time rather than a one-off. As we'll come on to in due course, that line of argument and reasoning has been put to bed by the subsequent decision of the Supreme Court in Bungie. But before we come to that, we've got a couple of first instance decision cases in the context of SPAs, which I think is appropriate now to look at. But bearing in mind they come before that clarification in the context of that debate going on. And the first is the decision of Aegeus and Quickfit behind tab 10, which is a decision at first instance of Mr. Justice Popplewell, as he then was. And to take the facts briefly from the head note, you'll see that this was a decision in 2014, concerned a share purchase agreement where there were allegations about breaches of warranty, and in particular, a a warranty was found to be breached in relation to the treatment of an accounting item known as time on cover bad debt, which was given an abbreviation in the head note as reflected in the judgment, just between D and E on page 1338. And you can then see the course of those proceedings are then traced through, and there was argument about whether or not subsequent events could be taken into account for purposes of assessing damages for breach of warranty. And to cut a long story short, Mr. Justice Popplewell concluded that that was conceptually possible and in an appropriate case could happen, but this case was not one of those cases where it should happen, and ultimately did so and disposed of the case in a curious coincidence, relying on the expert evidence of Mr. Mesher, who was, of course, our expert instructed in this case, and who was very quick to draw our attention to the fact that he'd been the expert in Aegeus and Quick Fit, and indeed is footnoted in his first report in support of why the court should not take the approach that Mr. Gates was suggesting. But so far as the points of principle are concerned, as discussed in this judgment, if we can perhaps just briefly look at them, that they start at 35 to 38. But before we get there, just to set the context for the argument, you may just want to briefly read paragraphs 11 and 12 and 13 to get the feel for the points which then follow before we get to the issues.
Shall we do that?
And then if you look at the bottom of the page, you see the heading, the issues, and you see the identification of the measure of loss for which breach of warranty was being awarded, as in this case, by reference to the Court of Appeal decision in Ryan Nathan and C.C. Bottlers, which ultimately was the case to do with when assessing the loss, whether or not the court takes the most favourable point in a range for the benefit of the breach party or not, and the Court of Appeal concluded that no, it should just take the actual figure, not the figure most favourable to the defendant. You then see reference to Mr. Mesher in paragraph 15 and his analysis, and you see then some discussion about the competing expert evidence as regards what was really going on, and you get to see the main issue, which was identified by the judge as being in valuing the company at the date of acquisition. This is paragraph 20. In valuing the company at the date of acquisition, the question arises: is account to be taken of what is known about the time on cover, whatever the abbreviation is, experience of the business since the date of acquisition? Can one use the benefit of hindsight? So that's the question posed. And you see the submissions, and then you see discussion starts at paragraph 23. And the first case that the judge considers is Senate Electrical Wholesalers, which was the additional authority which we asked to be included at the back of your authorities bundle. And the reason why we thought it would be useful to do so is because you'll see from paragraphs 24 through to 25, that's considered by Mr. Justice Popplewell, but he ultimately concludes it doesn't give him great assistance in resolving the current dispute before him because of a difficulty to know quite what was going on in terms of the findings made. So you might just briefly want to read paragraphs 24 and 25 before we then look at Senate. So if we now look at Senate Electrical itself, I think it should be included in the back of the authorities bundle behind tab 19. And this is an earlier decision of the Court of Appeal in 1999. And you'll see from the head note the composition of the court. And the context of the case was, again, a share purchase agreement case where there were issues arising as regards, firstly, assessment of damages, and secondly, there was also an issue in the Court of Appeal as to the notice provisions. And as I'm sure you'll be familiar with, the common drafting in SPA provisions that there'll be more restrictive limitation periods so far as notice is concerned. And that's often why people then use misrepresentation arguments or fraudulent misrepresentation arguments in order to circumvent those. So far as the findings are concerned in relation to the facts by the Court of Appeal, the particular passages I was going to take you to were the passages considered by Mr. Justice Popplewell, but also some earlier passages to put them in context. In order to understand what was being said by the Court of Appeal in this case. And you'll note that from the second page of the head note that the decision was a decision of the court given by a judgment by Lord Justice Stuart Smith. And the judgment itself starts at page 45. So there's just one judgment to analyse. You might just want to briefly note paragraph 9, where there's reference to the questions relating to damages and what Senate's primary case was in the court below. So you'll see that Senate's primary case, and it was contended actually successfully, their only case was that damages should be assessed by applying a price-earnings ratio derived from the actual transaction to the difference between the warranted profits and the actual profit. Ultimately, what the first instance judge did was something slightly different, and the Court of Appeal criticised him for that and overturned him on that basis. And so what we then have, so far as the observations later on as regards the points raised by for consideration by Mr. Justice Popplewell were dictum, were obiter, but nevertheless were argued and were dealt with. And we can see that paragraph 10, there was a contention that Senate had suffered no loss, and those submissions were made, and then you can see there was a both appeal and a cross appeal in this case, and you can see a brief summary of that at paragraph 12. And then the underlying facts are then dealt with from paragraph 13 onwards. The material part, just to briefly fix in your mind for present purposes, is the discussion about rebates, which is in paragraphs 18 and onwards. And the short point to note is that because of the nature of the business here, there was what was known as a rebate reserve, which was in effect a sum of money which would become due and payable later on, but for accounting reasons, of course, would then be put back into the accounts reference to the actual date when the trade occurred. But nevertheless, there was an element of uncertainty and some secrecy as regards the rebates and what would actually be paid. And ultimately, it was found by the judge at first instance that there had been an overstatement of the rebates giving rise to a breach of warranty. The rest of the detail probably doesn't matter for present purposes, other than just simply to note that point. You'll then see that there's discussion about Senate's case of trial, paragraph 24 onwards, and then you can see tracing through to Senate's case in the Court of Appeal at paragraph 28, and then you can see conclusions on the cross-appeal of the law. And I just briefly invite you to read paragraphs 30 through to 32 there, because in my respect for submission, it was those basic principles which were then influential to the conclusion by the Court of Appeal that hindsight could be accepted in an SBA case.
So should we read those?
Yes, please. In particular, you'll note reference to the well-known decision, British Westinghouse, emphasising in effect that quantum of damage is a question of fact by reference to guided by the compensatory principle, of course. And you'll see the passage in Ruxley, and in particular, the object of damages is always to compensate the plaintiff, not to punish the defendant. And we would highlight those words in the context of some of the submissions which have been pursued by the claimant on this appeal. But the significance of them, it then comes to then considering, the court then goes on to also consider STC's appeal, paragraphs 37 onwards. And you see then from paragraphs 38 onwards, you have the criticisms on behalf of STC as to the judgment below. And you see the different limbs or grounds to the argument A and B there. And it's limb B, which we're concentrating on for present purposes, though as I've already identified, they were successful in effect on limb A as well. And the point was being made was that in light of the true position, he should have concluded that there was no loss. And then we start with the natural justice point at paragraph A, sorry, heading A, natural justice point just above paragraph 39. There's analysis of the way the case is presented, and then ultimately we can skip through the passages really to the end of the reasoning, which we've highlighted from paragraphs 54 onwards, where the first point is determined in favour of this point of appeal, this ground. And then you see over the page then the part of the judgment which is considered by Mr. Justice Popplewell at first instance under heading B, what was the actual profit maintained in earnings in 1990. And you may just want to briefly read through paragraphs 56 to 60 of the judgment.
Shall we do that?
Now, our submissions on these paragraphs are as follows. That clearly, if you read paragraphs 56 and 60 together, the Court of Appeal are looking at hindsight in the context of looking at the actual figures which are emerged, irrespective of whether or not they're before or after the date of the transaction. And the reason why they're doing that is because they have in mind the earlier passages in the judgment, which I've taken your lordships to previously, about this being all about giving effect to the overriding compensatory principle. There is no material difference in our respectful submission between the arguments advanced by the learned friend on this case and the Senate, that the uncertainty in relation to the rebate reserves and what would come in after the event could be said to be an aspect of the business which the contractual risk was allocated to the buyer as part of the SPA contract. But you see none of that reasoning featuring in the Court of Appeal's judgment here. It is, in our respectful submission, straightforward reasoning and simple reasoning, and it goes back to the lodestar, which is the court is seeking to assess as accurately as it can the actual figures and position. And it is not restricted by any concept of allocation of risk, unless, of course, there's some sort of express clause to the contrary of the contract. And so thirdly, in our respectful submission, what you get from those passages in that judgment, whilst it's not binding on this court, because it's an obiter dicta, is persuasive as regards the approach, particularly when taken with the later decision in Bungie, which adopts a more expansive approach. The reason why I've taken that diversion or detour into Senate is to shed some light on the submissions which we make in relation to the Aegeus decision. And the headline point is that so far as the Aegeus decision is that Mr. Justice Popplewell was correct to recognise that hindsight can be taken into account in an appropriate case in SPA cases. In our respectful submission, the qualifications or caveats that he then seeks to suggest may be imposed in that respect can't stand in the light of the approach taken both in Senate and in the Court of Appeal, but also more significantly by the Supreme Court in Bungie in the later decision.
Can I just check that I missed something? What I wrote you down as saying was what you get, albeit obiter, especially when taken with Bungie, and then I ran out. What was I getting, especially when taken with Bungie, or have I?
What you get is that the starting point in Mr. Justice Popplewell's analysis, if we look at paragraph 35 to 38 now, because we're coming to the principles part of the judgment, is that he was absolutely right to recognise that in an appropriate case, hindsight can be taken into account. But the point which seemed to gather force in his judgment, and which was followed in effect in the Hunt Group by Mr. Justice Blair in first instance, was that in some way you layer on top of that a contractual allocation of risk concept in SPAs. It is, in our respectful submission, an additional caveat or gloss which is not merited.
So what we get is essentially that the overlay of allocation of contractual risk is not merited.
Yeah. Because in all single transaction cases, that's what's happening. The asset is passing across. Now, there may be some cases where there are specific clauses in the contract where the parties say, well, we're going to depart from the common law principles, and this is what we agree, but that's something different. If there is simply a share purchase agreement where an asset is transferred at a particular date, where I think, in our respectful submission, in reading it in light of the subsequent decision of Bungie, where we get to is that the idea that you qualify in some way or restrict the application of hindsight on the basis of contractual allocation of risk of loss is just simply...
There mustn't there be a limit to that? I mean, suppose that we were concerned with shares in an oil company, and the sale is made, I don't know, a couple of years ago, we suppose, when the oil price was very low. The purchaser of the company obviously takes into account the possibility of the oil price going up or the oil price going down, and he takes a view on the value of the company, taking into account those different possibilities. 2 years on, we know that the oil price has soared. The case comes on for trial. Does the judge say, look, we now know that the purchaser, far from having lost anything, has made a marvellous bargain because he's got the benefit of an oil company in circumstances where oil is terribly valuable?
No, I accept that point, and that point is made in Bungie, actually, which is that simply fluctuation in market prices, extraneous market prices, can't be used. And so what we're really searching for here is factors which are identified as relevant factors for assessment of the date of breach, but using subsequent events to inform you as to the actual loss suffered as a result of those breaches. So it's really a causation question. So on the causation question which you posed, there's no causal link which is referable to the breach allegations so far as a fluctuation in market prices is concerned. But if the contingency, as it is in this case, is the question of whether or not reputational damage will arise as a result of non-compliance with certain offence, if you can see that there's an additional cost of compliance necessary in order to avoid that non-compliance, that does resolve the issue, then that goes back to the very question of the breach which is being assessed in terms of the actual loss suffered by the claimant referable to that breach.
Can I explore it a moment? I mean, suppose that the purchaser here had known the truth at the date of the purchase. The purchaser would have said to himself, the company might be prosecuted, the license might be taken away, it might be absolutely disastrous. Or it might be that nothing will happen. Or it might be something in between. And the hypothetical purchaser sort of takes an overall view, taking account of the differing possibilities. Just as he does taking account of the differing possibilities with the price of oil. Why isn't it the same?
Because so far as the question of breach is concerned in relation to this case, it's an assessment of the additional costs which are required in order to ensure a compliant business, which is assessed by reference to 2 years' worth of post-events on the facts of this case, which show that those actual risks did not eventuate. And I accept the point that you're making to me, which is that in a conventional case, you would steer clear of that because you're introducing other factors which may be said not to have a relevance or bearing on the true assessment of loss at the date of breach. That's the mischief. And you're identifying rightly to me, well, what about market fluctuations? You could possibly suggest that that should be relevant, and of course I don't. And nor do I suggest necessarily that your normal starting point would be to take into account all this sort of material. But it was in this case. And I suppose the point I'm really emphasising is that if the hindsight exclusion is dealt with on the basis of a contractual risk type analysis, it's difficult to see any SPA case where the points which, albeit overturned by Senator in the Court of Appeal, would have any relevance at all. And so it proves too much in my respectful submission. And really, the fundamental principle is very simply back to the compensatory principle, which is the court is looking to assess the loss as accurately as possible with all the information it has available to it, including evidence after the event. There's still an inquiry as to what is and isn't an appropriate thing to take into account in that context. But if the very thing which the court is assessing as being relevant to the loss is known to be more accurate at a later date than at the earlier date, the court should take the later date. Or arguably it's appropriate to do so in certain circumstances if it's consistent with the overriding principle. So I'm not sure if it's a key point necessary for the purposes of this appeal, because I think there's an acceptance that in an appropriate case the court can depart from the hindsight principle. But the reason why I was making the point is because I think my learned friend seeks to develop an analysis which is, well, the risk associated with potentially reputational harm was a risk we took with the business. We worked hard on ensuring we didn't suffer those reputational losses. So therefore it would be unfair on us for you to get the benefit of that in circumstances when that's due to our hard work and the additional costs we've incurred in sending this elsewhere. And that might have some force if his own case wasn't depending on an examination of precisely what had been done by his client during that 2-year period.
I mean,
but it's not a principled answer to the question of including hindsight for the purposes of assessment.
I mean, the core question is, what was the company worth at the date that it was bought?
Yeah.
You think about what purchasers might have paid. Purchasers knowing the truth would evidently have taken account of the fact that the company had acted wrongfully in various respects and that consequences might flow from that. Later on, whether or not because of the efforts of the purchaser, things turn out well. Well, why should you have the benefit of the fact? The fact is that the purchaser overpaid at the time because it paid more than the company was worth.
The reason why we should have the benefit on the facts of this case is because the claimant had the benefit of the same factual inquiry over the 2-year period for the purposes of assessing the reduction in the earnings figure.
Is that the only reason why you should have the benefit of it?
Not the only reason, but that's the overriding stark point that arises in this case, which creates the injustice. If the court were to go down the route of saying, well, we're not going to apply hindsight at all, that would mean the claimant would have a nil figure for their damages award. It goes back to the same point I made right at the outset, because conceptually they're getting the benefit here of looking at this post-trading period for the purposes of assessing what would a compliant business cost to run.
Well, it's my mind. Can I just throw out one other point? Then obviously resume your suspicions properly. But I think I've understood you to suggest that cost of cure is of relevance to this, but that doesn't seem to bear on the reputational risk at all. Cost of cure might put up your multiplicand, but that doesn't take away the reputational risk of prosecution or risk of withdrawal of license or whatever.
Well, I think it does, because on the factual scenario we're dealing with here, there's common ground. The regulators didn't know they'd been lied to, and there was no actual loss of contracts at the time in question. So it was looking forward prospectively in relation to that position. So as soon as you end up in a scenario in this case where you identify either a cost of cure on the basis of transferring some of the materials to TRADB as an additional operational cost, or a capital cost of X amount for fixing the kit so that you have it being automatic. The hypothetical reasonably objective purchaser is going to look at that and say, well, that solved the problem. There is
but in circumstances where we suppose that the purchaser knows the truth, that there has been misconduct, why is putting things right for the future necessarily going to avoid the risk of prosecution for the past?
Because
the regulator's not going to find out.
No, there's a change in management, and there's the fact that we know that there wasn't actually a prosecution brought, and I'll take you to it in a few moments' time, but in the narrative section of the judge's judgment, they got an expert in about November, so within a month of the date of the completion, and that person said, well, actually the way it works with leachate is you've been in excess for 3 years. The way that the waste process cycle works is that whilst you may be in breach of your consents so far as putting it in the sewer to Welsh Water have their own limits, and they need to test and make sure they're within their own limits. And if there'd been a problem with them coping with their own limits, there would have been inquiry and they would have come back to you. So the fact they haven't suggests it's not a problem at their end, but that doesn't mean that they wouldn't be concerned about ensuring that they change the position, because from a point of view of financial cost and looking at their own limits, they want to try and minimise those ingredients at source as much as they can, because there's an additional cost to them associated with ensuring they're in compliance with their own limits. So there wasn't any real risk. Once you'd identified, in this case, you could solve the problem by incurring these additional costs. There wasn't to use the phraseology, objective, reasonably prudent market buyer in those circumstances is going to attribute anything to another reduction.
Yeah.
And indeed, that's what Mr. Mesher said in his evidence. He said you might have a range between an actual prosecution that's being brought, or a situation of complaints about persistent breaches and a potential threat of prosecution, but no actual prosecution brought. And that was his evidence. That's zero. So the facts of the case were not such that there was an existential threat to the business independent of that. Now we get the point that they would say, well, why should you get the benefit of us having acted responsibly, solved the problem, incur these additional costs, had to stop and start, etc., in order to solve the problem ourselves? But if they're relying on precisely that evidence in order to make good their lost claim, then it doesn't lie in their mouth, and I expect the submission to turn around and say the court can't then take it into account. That was all a bit of a diversion.
Yeah, it was,
from
I'm
the
afraid,
principles,
my
but
fault.
I think it's better to deal with these things as they arise while it's in your...
It boils down to a sort of the goose is sort of the gander argument.
Yeah.
And that the equation is unbalanced.
I think you have our main overriding point, if I can put it that way. The point I was really seeking to emphasise in this context is that actually in the light, and I probably should come to it now, but I've been talking about it so much I actually haven't taken to it. If you look at Bungie and what follows, I should just say that the relevant points within AGS, I don't think actually
I was thinking that.
I don't think I've actually taken you to those. And so I probably should, and that's at paragraph 35. It's marked up at page 1352.
And we get the racehorse analogy.
We get the racehorse analogy, which I can run with if you're interested in hearing a further development of it in due course. But we'll come on to that maybe. The short point is that we say, so far as AGS is concerned, all well and good from paragraphs 35 to 36, but in our respectful submission, the caveats or notes of caution which are sought to be added there are not consistent with either decision in Senate or in Bungie, which have liberated us from such sort of caveats or cautions to the position where, well, if I deal with them each in turn, I don't know if you've had a chance to read briefly through paragraphs 35 and 36, but so far as 37 is concerned, we see, having accepted, by reference to the horse analogy, that it's appropriate in certain circumstances to take into account hindsight in order to assess a contingent event which might be estimated at the date of breach, but becomes certain at a later date. Really all that is going back to, in our respectful submission, an application of the overriding compensatory principle. It's a sort of part of it. But then we get paragraph 37, two qualifications to the adoption approach. The first is that it can only be justified where it is necessary to give effect to the overriding compensatory principle. We don't disagree with the substance of what is being said there, but in the light of the decisions I've already taken to, and the latest decision in Bungie, which we'll come to shortly, we would submit the point might be articulated somewhat differently, which is because it is always necessary to have regard to and give effect to the overriding compensatory principle, that's why the courts will consider it appropriate to take into account hindsight. In other words, it's all happening under that general rule or umbrella, rather than it being a note of caution. It's hardwired into the concept. So far as the second notion, second note of caution, the sort of contractual allocation of risk point, I think I've probably already substantially addressed you on that, and the reasons why we say, in the light of the latest decision, really that type of approach is not the way that the court should approach it. I should just draw your attention to the fact that that approach was referred to and followed in the Hutt group, which is behind tab 9, decision of Mr. Justice Blair at first instance, and we've included it in the bundle for two reasons. One is because, just to show you this point, but the second is because it's the only case which talks about, to any significant degree, the idea of reducing the multiplier. And that point failed in the Hutt group case. But you'll see on the question of the principles, an adoption of certain principles which were common grounds weren't argued before the judge at paragraph 180. And then, again, also not argued, but based on the golden victory at 184. And in particular, it's at 1847, you see the following of the contractual allocation of risk type concept, which is followed there. and ultimately rejection of hindsight on the facts in this case. And that's included in part, you can see the passage in paragraphs 216 to 219. And the argument being that the contingencies were risks conferred on the buyer, which was entitled to the benefits as well as the burdens of that. The way I would respectfully put it is somewhat different, which is that those may all be good reasons why the court in certain cases would not have regard to subsequent events, but it's context and fact sensitive. It's not a principle by reference simply to SPA cases. And in my respect for submission, part of the reason perhaps why these two cases took the somewhat more cautious approach they did to the principles was because there was an argument at this time that actually golden victory and earlier cases were to do with continuous breach cases. They weren't to do with one-off cases. And that issue was tested before the Supreme Court in Bungie, which has liberated us, I think, from the caveats and qualifications which perhaps the judges were concerned to recognise in the earlier cases because of that academic argument. And the Bungie decision is behind tab 11. Page 215. And you'll see this decision in 2015. And in paragraph 44 of my skeleton, I think we've identified the passages in it which we rely on, but just briefly to take you to them. The two significant judgments I wanted to take you to, the first, that of Lord Sumption, and the second, that of Lord Toulson. The first, so far as Lord Sumption is concerned, is marked up at paragraph 22, and you'll note the reference to the argument that the principles might only apply to contracts for the supply of goods and services over a period and don't apply to a contract for a one-off sale. And there's a rejection of that by Lord Sumption there. And you see then the analysis, which has echoes of British Westinghouse about it, over the page within the same paragraph at page 1092, little b. The most that can be said about one-off contracts of sale is the facts may be different. And then we see at 23 the commercial certainty argument, which has strong parallels with the sort of contractual allocation of risk argument, is also raised and considered and rejected. And you can see that in paragraph 23 in particular. You can see the punch point at H. Commercial certainty is undoubtedly important, although its significance will inevitably vary from one contract to another, but it can rarely be thought to justify an award of substantial damages to someone who has not suffered any. In other words, if you actually have before you knowledge as to what has actually been suffered, you don't take an estimate at an earlier date, the date of breach. You can and should take a date, take into account evidence as to what's happened afterwards in order to inform you of that. There was also a brief discussion in this case about a damages clause. You can see that from heading above paragraph 24. And you'll note the cautious approach taken by Lord Sumption to the idea that parties should be taken to be contracting out of a common law damages exercise. Paragraphs 26 and 27. And ordinarily the parties would expect to, for there to be compensation for the true loss. So in short, and to repeat, I think submissions I've already made, but bearing in mind those line of authorities, we would suggest additional caveats as to allocation of risk are inappropriate, save where the contract expressly provides for the same in the context of assessing damages. And in short, taking into account hindsight in certain cases or taking a later date for assessment is not a qualification to the overriding compensatory principle, but is in order to give effect to it and to give effect to identifying the true loss. And that's a fact and context-sensitive inquiry depending on the case before the court. So conceptually, we might say that there are three categories of case. A category 1 case where the general rule is applied, damage is assessed at the date of breach and the court does not have regard to subsequent events when assessing value. A category 2 case where subsequent events are had regard to when informing the assessment of value at the date of breach. Or a category 3 case where the court takes a date later from the date of breach. Now this case, as a result of the way that the case was advanced on quantum in the court below and as upheld by the judge, was a category 2 case already. Because subsequent events were had regard to when informing the assessment of value at the date of breach. And in reality, what the judge has done is created a category 4 case here, which is not recognised in any of the authorities, which is that these subsequent events are had regard to for some purposes, but not for others. And to make matters worse, which travail the same factual inquiry over the same 2-year period in circumstances where we, as a result of that inquiry, know what the actual position is. And our respectful submission, it is inconsistent with the overriding compensatory principle to do that, to take it into account when assessing a reduced multiplicand or maintainable earnings figure, but then choose to ignore those same facts when accepting the notion of a reduced multiplier. Nothing in Aegeus or any of the authorities comes anywhere close to supporting such an approach. The contractual risks have been allocated to have been relaxed to their benefit, and they cannot take the relaxation of that without taking the associated burden with it. It's a feature, I think, which crops up in other areas of the law, probably familiar to you all. Now, independently of whatever submissions we make about the sort of hindsight principle, there is this core question of consistency in decision making by a first instance judge, which is an important point not to lose sight of in this case, and which we submit as a separate strand of our grounds of appeal. And we managed to locate a passage in a recent Supreme Court decision which touches on this point and explains why this would be an independent ground in its own right. It's the decision of Chief Constable and Greater Manchester Police and another. Should be behind tab 20 right at the back of the authorities bundle, hopefully. It's a decision of the Supreme Court in 2018 on facts which are far removed from here. But the reason why we cite it is for the discussion about the circumstances in which it might be appropriate for an appellate court to interfere with a first instance decision. And in particular, obviously the context in this case arose in relation to a factually different decision-making process, but there's some general statements of principle in the judgment of Lord Carnworth at paragraph 64, which is marked up at page 4102. And you'll see there that there's discussion about whether or not there can be an intervention limited to a significant error of principle, and that's considered to be too narrow approach, at least if it's to be taken as implying the appellate court has to point to a specific principle, whether of law, policy, or practice, which has been infringed by the judgment court below. Decision may be wrong, not because of some specific error or principle in that narrow sense, but because of an identifiable flaw in the judge's reasoning, such as a gap in logic, a lack of consistency, we emphasise, or a failure to take account of some material factor which undermines the cogency of the conclusion. So we submit as an independent strand of our first ground that this lack of consistency was a significant error and resulted in the approach below being wrong. And if we just turn back to our skeleton argument at this stage, I'll just take stock of where we've got to on the different parts of the submissions. You'll see at the end of our ground one section from paragraphs 52 onwards, we set out our submissions on inconsistency. And if you've got the point, I probably don't need to dwell on it any further, but just so you understand in terms of how we got to where we got to, the approach of the judge so far as the figures he took were based on figures which Mr. Mesher suggested was not the safest approach because of the reasons he identified in his report, but was a safer, I think is the way he put it, approach to that adopted by Mr. Gates. And ultimately it was his evidence which then became the foundation for the findings made by the judge. And in that respect, you'll see that in particular, that was based on the reasoning of Mr. Mesher. I should probably just take you to the part of the report where the reasoning is based, just so you can see how it's evolved. But briefly, before I do that, because it's responsive to Mr. Gates, just briefly take you to his as well. So if we could go into the supplemental guide for the purposes of these submissions and briefly look at, firstly, Mr. Gates's report. And I should say that the points I'm going to make, I think, hopefully also illuminate the second ground of appeal on the question of the multiplier and the reduction of the multiplier. But if I can skip through this quite quickly, the Gates report starts at page 42, behind tab 3, and so a sequential exchange, and we have the methodology used by Mr. Gates, and I'd invite you just simply to note, for present purposes, under that heading at page 46, the 4th and the 7th bullet points, so far as what was done by Mr. Gates in terms of the review work carried out by him. So a review of the performance in the year prior to and the 2-year period prior to and after the transaction, and then a comparison of Department 2, the wet waste of the company, the overall performance in the 2 years in question.
Sorry, I've missed that. Where are you?
Under heading methodology used,
yes.
1.5.1, 4th bullet point, a review of the performance of the company, and then skip on 2 bullets, a comparison of Department 2.
Yes, I see.
So there's more of it, but just those are the sort of headline points really. And you can then see in terms of method of assessing the warranty claim.
So sorry, that bullet point is a comparison of the 2 years prior with the 2 years afterwards.
Yes, a comparison of Department 2 overall performance in the 2 years prior to the transaction and the 2 years after the transaction. Yeah, so both. And there's an interesting discussion in Mr. Gates' report under 2.4 about what he's doing isn't hindsight, and he seeks to sort of justify what he's doing. And you can see what he says why he considers it appropriate 2.4.2 to adopt this approach at page 50, and then you can see his assertion that he's not taking into account any hindsight at 2.4.6, and that came under some challenge from Mr. Mesher in the report to follow.
Yeah.
If you want to look at the challenge by Mr. Mesher on that, just to have the note for that, just skip onto that, you can see that his report is at tab 4, page 70, and he draws our attention to the fact that he was involved in the Aegeas case at 2.9, and then we have at 3.44 at page 90. Whilst Mr. Gate acknowledges that hindsight must be avoided in the calculation of damages, the method he has employed in the calculation of damages relies on the total wet waste results of the business post-sale, and thereby, in all practicality, he has indeed used hindsight in his calculations. And then he goes on to set out a host of factors as to why that's unsafe, and ideally no reference should be made to the post-sale period. And ultimately, he offers up a view to the court as to an alternative, which is the cost of cure cap. But he also, in the course of his judgment, analyses Mr. Gates' position in case of further argument, and comes up with a more refined analysis and calculation. And it's 4.29 and 430, which is really where we ended up in the judgment. So far as the analysis is concerned. So if you want to just skip briefly to that just to get the point, but it's at page 101.
So we should just read those paragraphs.
Yeah. So this is the foundation, which is then lifted by the judge and taken into the judgment. And you note Mr. Mesher in 4.33 notes that it could be susceptible to the same criticisms, but is better in any event than the Gates analysis. And then we see the passage in his judgment then when he sets out what, in his view, is the safest and best approach, which is the damages capped by reference to the Hydro Venturi report, which is 4.35 onwards. And you'll see that's picked up in the judgment where in 4.38 you can see the three different options are identified in terms of solving the problem, and ultimately option 3 at the top of page 103 being a fully automated system costing the region of 93 to 113. There was some subsequent argument about time for that to be put in place and so on and so forth, but in broad terms those were the figures. Yeah. So, but just going back, forwards as to how Mr. Gates responded to that point, it's just quite illuminating to see how Mr. Gates then deals with that point in his supplemental report. So there's a joint statement at tab 5, where in effect you'll see Mr. Mesher maintains his position on the inappropriateness of a reduction to the multiplier. For example, if you look at page 112 next to little d, if you look at the right-hand side box, you see a summary of Mr. Mesh's evidence in that respect, which, as you can see from the judge's analysis of his evidence in paragraph 139 of the judgment, was in effect where he remained.
Sorry, let me just read this. Yes.
And just to complete the picture so far as this question about hindsight point is concerned as well, if you look at Mr. Gates' supplemental report on tab 6, you can see at 2.4 at page 118, you may just want to familiarise yourself with the territory, but it's under heading My Methodology. Its response to the criticisms about the approach, and he sets out 3 potential options for how the losses might be assessed. And suggests that the other options just simply weren't feasible. And he then says, therefore, that the option 3 approach that he's taken is the most appropriate method to use to assess the likely unrecorded wet-based costs in the period pre-completion. He goes on to say, consider this as the detailed information required for the purposes of my work is available, and the underlying nature of GD has remained the same in the period of my review before and after the acquisition, with significantly the same customers. So what he's basically saying is that other extraneous factors which might render this an unsafe exercise, he considers can safely be excluded.
Can we just think for a moment about option 2,
Yeah.
which is also not feasible, which is comparing the performance with a third-party business. So suppose you had figures for a third-party business for the years prior to the sale. That wouldn't involve any use of hindsight.
No.
You'd be looking at how a comparable business performed and how far you could infer from that this business would have done less well if it had been compliant. Now you find figures for the comparable business for the next year, because you haven't got figures for the earlier years, but you can see how the comparable business did the next year. And it said, well, you can infer from that how this business would have done in that year, in the years preceding the transaction, because a comparable business did this. That's hindsight, is it?
It's the best evidence available at the time of assessment. And it simply goes back to that, doesn't it? That if the court is looking to try and assess as best it can, as accurately it can, what the actual loss is, subject to arguments about, well, are you wrongly allowing other factors to come into the equation here, such as to do with special performance by the defendants or other factors? If you can be satisfied that those don't infect the process, if there's evidence which emerges after the event which shows what was conjectural and estimate is now known fact, or better known fact, then the court can take into account. It's as simple as that, really.
Yes. I'm not sure that it's comparable to the
But I don't know if
use of hindsight that you're encouraging elsewhere.
But I think our short point is this: is that independent of the point about them using this material, precisely the same material, but precisely the same period, showing that there wasn't a problem. Independent of that, a court could properly take into account that evidence.
Yeah.
It's a question. It's a question ultimately for the court to answer by reference to the Pancanian concept or formulation, which is in doing so, is the court more accurately assessing the true or actual loss suffered by the claimant in relation to the particular breach in question. And there's a strong tendency, in my respect for submission, for the court to recognise that where it can see and has evidence before it that what was a contingent risk which might have been assessed at a higher figure is actually known to risk not have arisen, and it's known by the court not to have arisen, then really the claimant's getting a windfall. And that's inconsistent with the compensatory principle.
Yeah.
If the court hasn't gone down that inquiry, it may well be said that, well, the court said, well, that's the approach I've taken. I've done it for X, Y, Z reasons. These are all good reasons. See Mr. Gates' report. He's convincingly explained to me why I shouldn't go anywhere near any of this and should just stick to this approach, and then we'd be in a different case.
Yeah.
We lost that argument in the first instance. So we're now in the unusual situation of seeking to adopt the argument made against us, to say, well, if you're jolly well running that point, then you can't just take the benefit of it. But I think source, goose, etc. is already the point understood. So in terms of the other points, just the forensic points, I just draw to your attention in terms of Gates and what he did and what he looked at. I mean, there was a forensic review by both experts in relation to the detail of what happened in each of the businesses in the wet waste department. And just to sort of pick up on that, just so you've got the references for it, if you go back to 55, so Gates' report, and you see what he did,
I'm sorry, we're going back to...
so Mr. Gates' first report here,
yes.
So just to see the review that he did, which was that layered on top by Mr. Mesher. At page 55, you see matters affecting the valuation. You can see performance of Department 2 wet waste. And this picked up on the bullet point that I indicated right at the outset in terms of the methodology. And you can see he's carried out a forensic review of the department of the performance of Department 2. He notes as part of the overall business, and then he looks at the extracts, the company's sage accounting records for the 2 years pre and post acquisition for Department 2 wet waste, and then he looks at the sales over that period, and he notes that the table demonstrates the overall performance in terms of sales is reasonably consistent, whereas waste disposal costs significantly increase after the transaction. So that's right on both to prove the breach and also to formulate the quantum calculation. And then he analyses the Newport contract, which is the contract which is concerned with the leachate, and how the disposal costs were risen. He looks at competitors, so for example at 4.1.17, so that he can be satisfied that what's going on with the figures isn't influenced by something else that may be going on in terms of the external market that might be influencing any of this, and satisfies himself that it's appropriate. Now, the major flaw in all of this was that he didn't actually offer us a figure for the specific breaches of warranty. So, and that was a major concern we had in relation to this case right from the outset. We didn't have, from Mr. Gates' evidence, what loss flowed from the particular breaches of warranty. And ultimately, we now know the judge only found breaches of any material relevance in relation to the leachate contract, and so therefore a different approach was required in order to assess that, and ultimately Mr. Mesher's analysis was accepted and taken up by the judgment, his judgment in that respect. But the point I wanted to emphasise is we're probably mixing our metaphors here with our source, goose gander, harehounds. They're all there, and I offered up the tantalising prospect I might try a horse analogy, and it might fall at the first hurdle, but I'll give it a go anyway. So the horse is sold and warranted as free from defects. In fact, it has a latent muscle defect, which means it A, may not be able to sustain racing speed for sufficient time on certain longer races, and B, there may also be an issue to do with whether it can cope with hedges on shorter races. The horse has raced before damages are assessed, and it is known that A is a problem. So sustaining racing speed over certain long races is a problem, but the jumping is not. Both are relevant to assessing value. Rather than assessing A prospectively, the court awards the amount based on what is known about the racing performance on actual races after the event. Those races included the shorter races with hedges, and this was not identified as a problem. However, the court declines to take that into account and instead offers a percentage based on the risk of B being a problem. In short, in our respectful submission, the approach taken on this case is indefendable. Now, I think I've probably done to death ground 1. Ground 2 I should probably not leave untouched, so I'll briefly deal with ground 2 because it's an independent ground of our ground 1, but is informed to some respects by our ground 2. You've got our submissions hopefully neatly summarised at paragraphs 57 to 89 of our skeleton argument. And you'll see that our main complaint in this respect is that what happened here is highly unusual, that we had an adjustment to the multiplier which had the consequence of more than doubling the value of the claim. And in our respectful submission, independent of all the submissions I've already made, the adjustment was arbitrary, unreasoned, or left out to account relevant factors and ended up with an excessive figure, manifestly excessive figure. And indeed, no adjustment was justified. Now, we set out in paragraphs 57 and onwards the reasoning of the judge. And we note his rejection of the Gates discount at paragraph 58. And we then have, and I think it's maybe useful then to take up the judgment here at call behind tab 5. We have the reasoning and conclusion section of the judgment at 290, I think it is from memory. So it starts at 2.8. The relevant part of this starts, so far as the reductions is concerned, at 2.88, and I've been dealing with ground 1, the last sentence at the end of 2.88, but then we have 2.89 where various findings are made so far as the reasons why Gates' suggestion of 25% is rejected. And he rejects the notion of unknown things coming out of the woodwork. And he also notes, from a valuation point of view, they were unlikely to be continued or repeated by the new owners of the company. And therefore, he doesn't accept the occasion of reputational damage that ought to be reflected in the valuation so far as past non-compliances were concerned, the risk of cess weight or tank bottom waste. He also says, I'm not persuaded that the breaches in respect of leachate and misleading the regulators created a genuine risk to the viability of the business of the dry side. Any discount would, in my view, properly relate only to the risks of the ongoing wet waste division over and above the reduction in the leachate business. The change of ownership of the company would itself tend to minimise the risk of adverse consequences of the regulators. Again, I do not accept it's justified to value business on the basis of possible concealed breaches, which there's no evidence. And then he concludes, in my judgment, the discount of the multiplier is to be ascertained, as Mr. Mesh has suggested, by choosing a figure at an appropriate point within the range of acceptable multipliers for an EV/EBITDA valuation. Mr. Mesh had considered the appropriate range was between 3.8 and 4.5. Although the specific figures at either end of this range were suggested by a fairly limited examination comparable, I accept his opinion as to range. Then says, having regard to the matters I've referred to above, I consider that the risk of reputational damage is appropriately reflected by discounting the multiplier from 4.2 to 4. Well, just pausing there, well, why is our rhetorical question.
What could he have said?
Well,
I mean, if he's got to the position where he thinks, well, a purchaser, knowing the facts, would have reduced their bid a bit, but there are various factors which reduce the significance of that, and it's appropriate to have regard to the overall picture as we see back in 283. What more can he say to explain why it's 4.2 rather than why it's a reduction of 0.2 rather than a reduction of 0.3?
I think what we need to have, which is lacking, is analysis of why the reduction that he's picked is justified. Why that specific reduction, and it's just simply absent from the reasoning. I can't go to my client and say, do you know what? This is the judge has set out his reasoning here as to why this specific reduction is justified. We don't get that. We get the reasoning as to why Gates is completely overblown.
And he's also explained why he thinks some reduction is justified.
He has, but he's not explained what that might be.
So we've got to a position where he's explained that some reduction is justified. He says that what's been proposed by Mr. Gates is much too much, because he sets out various reasons, and he cross-checks to find that he's reducing the purchase price by 11.5% or whatever. And what more can he say?
Well, for example, what we don't know as part of the reasoning is the oddity about changing a multiplier is it's not applied just to the specific part of the businesses which the course is looking at. It applies to the whole of the maintainable earnings figure. And a major concern we've got about the judge's reasoning analysis in relation to this is that he's taken a reduction which has caused more than a doubling of the figure so far as the actual loss is concerned, in circumstances where only a minute change to the multiplier can have a huge impact on the figure, because you're taking the whole of the earnings across the whole of the business. Now, where do we get that he's actually addressed his mind to the fact that in relation to the adjustment here, on the basis of his own findings, it can only be justified by reference to a part of the wet-based business?
I mean, he's brought out in his comments on Mr. Gates that he's got in mind the fact that he's only dealing with the wet waste business. He says it's not going to affect the dry side. And in 291, he recognises the consequence, which is 11.5% of the purchase price, which obviously he feels is overall appropriate.
So I guess all that is the final part of the reason which is missing. So what we don't have is the reason why I consider a reduction down to 4.2, down to 4, or rather than a lot larger or greater amount, is X, Y, Z. The only way that you could seek to try and impute such a reasoning into it is to say, well, it follows automatically, because he's rejected what the factors on Gates. Those are the necessary stepping stones to his reasoning in paragraph 290, and they can translate across easily and readily. And Mr. Sims, what's your fuss about here? You know, judges have to pick a figure somewhere. Type riposte to me. But our concern is in the context of the situation where you've already reduced the maintainable earnings figure to take account of the specific costs associated with the increased costs of running an operational system. And you already have the finding that this is restricted to an adjustment in relation to the wet waste business. As a result of reputational risk caused by a very small part of that wet waste business, you end up with more than a doubling of the damages award. And what we really are missing is some sort of specific reasoning as to why that specific figure is chosen in the context of specifically why that adjustment.
Well, hasn't he done that, Mr. Sims? Because if you look at paragraph 290, he's saying Mr. Mesher has put forward the range from 3.8 to 4.5. I accept that range. And then having regard to the matters that I've already referred to, so those are the matters, for example, in 289, where he's considered wet versus dry and other risks and what he's willing to accept and not. Taking those into account, he plumps for this reduction in the middle of the range. So, hasn't he done it?
Well, in my respect for submission, not. Because if I go to my client and my client says to me, okay, Mr. Sims, why is it not 4.15, which might deliver 10 or 50 or 1,000 rather than down to 4, which has doubled the damages awarded here? What is the reason why? Because all those reasons that the judge has listed out as to reasons why Mr. Gates' evidence should be rejected all show why there should be either a lesser discount or no discount at all.
So there should have been another paragraph which then sets out the elements that are already in 289 and puts some kind of figure beside them.
Well,
as a result of that, I come down by point whatever, which equals X pounds.
But it would actually have to be another paragraph which said something slightly different, which is actually a very large discount is justified here, which will more than double the damages figure, because the hypothetical purchaser will have X, Y, Z reasons why they would have insisted on a much greater reduction.
I'm not sure, but you say what you'd have said to your client. I'm not sure that you wouldn't have said to your client, you know, in the end, it's going to be a matter of impression rather.
Well,
there is no absolutely scientifically correct answer to the extent of the reduction that the judge has to plump for a figure.
Well, I would respectfully submit that a client could reasonably expect more than that explanation from me, and that's supported by the approach taken by the Court of Appeal in Senate. And this is the second part of the reasoning in Senate, which I was wanting to take you back to on this point. And it's the passage, so I think that's tab 19 in your authority fund. And it's paragraph 67 and 68 in particular, I would like you to read in this context. So page 437 of the internal report.
Shall we read those?
Yes, please. So if I could just summarise my points on this, I think it's this, that first of all, I invite you to look at paragraph 60 of our skeleton. And submissions of this nature before this court are naturally context sensitive. What the court might expect for a relatively small sum of money may not be necessarily the same for a much more substantial sum. But what we have here is a very significant sum of money, indeed the largest sum. So this is the biggest change in terms of the numbers in the judge's judgment. And if you read paragraph 289, all the reasons you get are reasons why the reduction should be either nothing or very modest indeed. You get no reasoning the other way as to why we end up with more than half the profit from the wet waste department being wiped out because of what the reasonably prudent buyer would have thought.
Can I just understand those figures? I'm not sure I focused on them especially.
Yeah.
So, as you say, the gross profit from wet waste is 580,000.
Yeah. So if you reduce that by the amount referable to the leachate breaches,
Yep.
because you're already making your reduction for that, you're looking at wider risk beyond that.
So
we've got.
So he's reduced the multiplicand, so to speak, to 420,000. Let's see.
You're reducing the overall profit figure down, yes, to look at what's left of the profit that you're considering a reasonable buyer might think, actually, that is a risk for me.
Yes.
And what might seem as a modest 5% reduction in the multiplier ends up with being more than half of that.
So more than half of the annual profit.
Exactly.
Is that an appropriate comparison? I mean, you're not just buying an annual profit, you're buying an income stream.
If you look at simply the percentages of what this derives to the figures, either way, it doesn't matter if you look at that or the judge's, I think it was earlier, 283 paragraph.
Yes.
He sets out the figures. What we don't get in the judgment is an articulation of why such a high figure.
So
we get articulation of the reasons why the figure should be very low.
I see that. So just is the appropriate comparison really with the capital figure which the judge gives in 283 as between 580,000 and 780,000?
Well, I think I've taken that as my starting point, haven't I? So I've said it's a range of 580 to 780, and then what I've tried to do is I've tried to the judge's analysis in paragraph 283 doesn't adopt quite the same approach as the experts in terms of the way they've gone about it. He's just using that as a cross-check, I think, in terms of the calculations. The point that I was trying to make was that if you there's an element of the leachate profit within that calculation which you're already stripping out for the purposes of your calculation exercise. So I think the maths does work, that in broad terms the proportionate figure which you're left with is 420, but if my own friend suggests there's a different calculation we'll be looking at, I'll engage with that.
I suspect I buy your point, but I just wonder whether I buy it in quite the same way, because it looks as though you're saying, well, if you award damages of 382,000, you're taking away more than half the profit, but that isn't the appropriate comparison, really, is it?
Well, no, because you have to start off with the 159 figure, which you've already. So if you look at paragraph 59 of our skeleton, our starting point is if you reduce the maintainable earnings figure,
yes,
you get a loss figure of 159.
Yes.
That's already a loss which is being awarded
yes.
as a result of the of the changes to the figures on the leachate. Even if you assume for present purposes that my maths doesn't.
Well, I wonder whether the
across.
comparison is with the capital value he's attributing to the wet waste division.
Well, I think I've already done that at the end of paragraph. Well, both I and the judge have done that at the end of paragraph 283, which is elimination of the wet waste division would result in a diminution of the value of business between 580 and 780.
Yes.
So those are the judge's own figures. In our respectful submission, you have to make a further deduction for the element of leachate profitability within that figure because you're already making that deduction. So you have necessarily a lesser figure. We think our calculations work as set out in 60, but your lordship thinks there's a different.
Well, no, it's just when you say the seemingly modest reduction ends up with more than half of the profit. Well, on the face of it, you're just taking away more than half the profit for the year.
No. You're taking more than half of the profit of the value attributed to the business, not just for that 1 year. So my calculation isn't just done on the basis of a yearly figure.
So when you, I think you're right, but when you say taking the judge's own figures suggests that the gross profit is 580,000 and the net profit is 420,000. Those are annual figures.
No. The judge's figures aren't annual. No, he's looking at the percentage of those figures and then looking at what those are a percentage of the profit element of the value attributed to the business. So it's not an annual basis at 283.
I see, yes. I probably haven't read that carefully enough.
Now, I would accept the criticism if I was trying to do an annual basis.
It really doesn't matter. But,
So is the value, it's the diminution in value. What we're doing is we're using the profit figures to try and allocate percentages to it in order to sense check what it is in terms of the business overall.
so is the reference to gross profit erroneous? You're really dealing with value.
That you may be right. Yeah, it should be the contribution of that element of value.
I follow that.
Yes, there's an error in my skeleton argument on that. Yeah, I think you're right.
Yes.
Apologies if I was slow on that point. But the overall point is I think made good, which is and I maintain it, which is that the factors that the judge identified are all about reduction and moving away from gauge. But what we don't have is the explanation on the other side of it as to why we end up with a figure which is even more than the certain known reduction of 159 associated with the maintainable earnings figure.
Yeah.
And I think a client and a person who's expected to accept a judgment is entitled to have that, know how it's got to, and it's just not there. And for the reasons which I'm sure you'll all be familiar with, as the reasons why we need reasons, it generates appeals, it generates a lack of buy-in, etc., etc. So that was that point, and there are other points on ground two, which I think I can rest my case for present purposes on the skeleton, subject to just lunchtime review from those.
We've already, as a result of my getting puzzled over the figures, gone past 1 o'clock.
Yeah, so I think that's probably a convenient moment. I will take stock as to whether or not I can just rest my case on the written case on the basis of that. Hopefully I can, in which case my own friend will have a clean start. But if there are any brief matters, I'll mention them after the short adjournment.
In which case, so we say 2:05.
Thank you very much.